everybody, News Now Wyoming here. So I've been seeing some questions about what charges Chauvin is facing, how the jury will find guilty, what do they have to find in each charge. And so for today, I created a fun, what I find it to be a fun document. I realize not everybody is as boring as I am, but this is just a fun way of academic exploration, if you will. This is not intended to be legal advice. I am certainly not an attorney. I am not a lawyer in Minnesota. I barely know the Minnesota laws. I read a lot of statutes this morning and I looked at some case law, but not about jury instructions. I looked at some definitions that the courts have found to help in this. So this is definitely not legal advice. And I will still call myself ignorant of Minnesota law because I didn't dig too deeply into case law. But let's go ahead and get started here. Again, and I do want to point out that jury instructions can be extremely long. It's not unusual for 50 pages of jury instructions. So this is no way complete. These are just some of the preliminaries, some of the basics that they are going to be covering in their jury instructions, including the charging documents, which we'll get to. So first one is very important. If the defendant does not take the stand, which I do think he should, but if he does not, that cannot be considered in your deliberations. He has a Fifth Amendment right not to take the stand. So the defendant does not have to get on the stand. I believe that he should, because it'll speak to his intention, which we'll be talking about here in a minute in these charging documents. Just because a defendant is on trial does not mean he is guilty, right? This is that you have a presumption of innocence when you enter court. So do not go into it with that presumption of guilt. Just because he was arrested does not mean he was guilty. Jury may consider whether a witness is credible or how much of their testimony is to be believed. This is going to be important when it comes to the expert witnesses or possibly other witnesses. The defense is going to come in with their witnesses that say the only reason George Floyd is dead is because of the illegal drugs he took. The prosecution is going to present expert witnesses that say no, the officer's actions in holding him down for 4 minutes after he was no longer responsive, that is what ultimately caused his death. So who do you believe? Two people that claim to be experts. Oh my gosh, how do you believe? So the instructions are going to say you guys can consider any evidence and any witness to be believable based upon their testimony and the evidence presented. Only evidence presented in the trial may be considered. Knowledge from outside the courtroom are not to be considered or discussed. And I said this yesterday in my video about forget that blue. But I said this yesterday in my video about why I wouldn't be a good juror, right? That I am biased. I've got a lot more knowledge, and it would be hard for me to consider things without considering my knowledge of the courts and of the justice system. It would be hard for me to be unbiased. So I would make a horrible juror for just about any trial out there. Then attached are the court's interpretations of what the law is. The jury is not to consider whether that law is appropriate. And jury nullification is very controversial. However, Minnesota court law is showing that jury nullification is bad. It is not to be considered by jurors. And now whether or not that is legal, I don't know. However, jury nullification is not allowed under Minnesota case law. So, questionable. There will be an instruction clarifying what cause the death means. So this could be that the jury may have to find that George Floyd died only because of what the officer did. That the illegal drugs had no part in it. Or it could be that they have to find that the Chauvin's actions were 50% of the cause. We don't know. This is going to be hard to predict of what the judge will rule on this. There will be some sort of instruction that needs to find that the actions of the defendant went beyond what a reasonable officer would do in order to be found guilty of any of the three charges. So this will be an important instruction. Would a reasonable officer have held his knee on a defendant who was handcuffed and no longer fighting back? Is that what a reasonable officer would find? I think that's got to be found before any of the others can be deliberated. Was this what a reasonable officer would do? 9 minutes. And again, if you watch the video that was released last week, I believe it was, of that officer, and he says, hey, I think that he is unresponsive, and he picks up his leg and he drops it. The knee of Chauvin is on George Floyd for 4 minutes and I think 8 seconds after that interaction took place. So, would a reasonable officer keep his knee there after being told he is unresponsive? That's going to be key for everything else. Alright, so let's look at the actual charging documents. These are from the statute themselves. First charge is second-degree murder unintentional while committing a felony. So first, under second-degree unintentional murder, it is required that you find that Officer Chauvin intentionally committed felony assault. And then I gave a couple definitions. Or here it is. Whoever assaults another and inflicts great bodily harm may be sentenced to imprisonment for not more than 20 years or to payment of a fine of not more than $30,000 or both. The statute in 609 defines great bodily harm as bodily injury which creates a high probability of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss of impairment of the function of any bodily member or organ or serious bodily harm. Whew, big words there. High probability of death. That's what great bodily harm is. Defines assault as an act done with intent to cause fear in another of immediately bodily harm or death, or, and number 2 is more important here, the intentional infliction of or attempt to inflict bodily harm upon another. So I went with number 2 here because it's an or statement, so they don't have to find both. It's an or statement. So the intentional infliction. So, with intent, the statute defines as the actor either has a purpose to do the thing or cause the result specified, or believes that the act, if successful, will cause the result. So, to find a person, first we've got to find felony assault, right? So, to find a person, you must find each factor below beyond all reasonable doubt. All 12 jurors must be unanimous in this decision. That defendant Chauvin did intentionally inflict bodily harm, did intentional infliction of bodily harm on victim George Floyd. Did he intend to cause bodily harm? And that defendant Chauvin caused great bodily harm upon George Floyd, i.e., did he die? Okay, so if both of these are found, he has committed felony assault. You then must further find for murder in the second degree that defendant Chauvin caused death upon victim George Floyd. Intention of killing is not required of this charge. So, if you intended to cause assault, felony assault, we don't have to consider whether or not you intended to kill him, only that you caused his death. If the above is found as true, you have found the defendant guilty of murder in the second degree, and you may stop with deliberations. If any factors are found as not present, you must return a not guilty verdict and continue with deliberations on count 2 and 3. So third degree murder, perpetrating eminently dangerous act and evincing depraved mind. To find a person guilty of murder in the third degree, you must find the below factors. Let's go ahead and fix that. You are not to consider what the defendant intended to do, only what happened. Defendant Chauvin did cause the death of victim George Floyd. Again, that is required. Did he cause the death of the victim? Defendant Chauvin did so by doing an act that was dangerous to George Floyd without regard for his life. If both factors are met by all 12 jurors beyond reasonable doubt, you have found defendant guilty of murder in the third degree and may end deliberations. There is no jury consensus, or you all factors are met, he is if not guilty of third degree murder. You may continue deliberations on count 3. So count 3 is second degree manslaughter, culpable negligence, creating unreasonable risk. Manslaughter in the second degree. A person who causes the death of another by any of the following means is guilty of manslaughter in the second degree and may be sentenced to imprisonment. Okay. By the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. Or, okay, and so that part is unimportant because we didn't go with 2. Culpable, because they didn't go with 2. These are based off of the charging documents, the amended charging documents of Chauvin, right? So they didn't take into consideration 2. Culpable negligence has been defined by Minnesota courts as the acts that are grossly negligent combined with recklessness. To find defendant guilty of manslaughter in the second degree, you must find beyond all reasonable doubt that defendant Chauvin, well, I guess these can all be deleted, caused the death of victim caused the death, once again, that's important. Actions were grossly negligent, actions were reckless, and that his actions caused great bodily harm. If all 4 factors are met beyond all reasonable doubt by all 12 jurors, you must find defendant guilty of manslaughter in the second degree. If any, and in fact I'm going to underline any factors are not met, you must find defendant not guilty of manslaughter. So there we go, you guys. There are the mock jury instructions. Again, there's a lot of legalese I removed out of this. I wanted it to be a short exercise in academia, right? This is just so we can have a better understanding of what is required. I will make this document available for everybody to view. And thank you guys for joining. What do you think? Let me know in the comments. Make sure you hit like and subscribe. Have a great day.